Does a person lose their license in Indiana immediately after a DUI arrest? That answer is super complicated, unfortunately. But in Indiana, if a person blows 0.08 or their blood out of their arm comes back at 0.08 or greater, the judge is supposed to take away the person's ability to drive at the initial hearing. Initial hearings are usually pretty quick in DUI cases, and so most people who have chemical test results, blood or breath, and it's 0.08 or greater, are losing their license immediately after a DUI arrest. Now, that's the law. Now, some judges in this great state, which we have 92 counties and multiple judges inside the counties, some judges say, hey, no, Mark, if there is an arrest for a DUI, then I get to take a driver's license. I don't think that's the law. I disagree, but I'm not a judge. They can do what they want, I guess. So those judges who subscribe to that belief take away the license, even if there is no breath or blood result. Maybe the blood is still being tested. So the license is not supposed to be suspended if you do not provide a blood or a breath and there's not a refusal, but some judges still take it. Now, some judges who do not suspend the driver's license if there's no breath or blood will suspend that license when the blood results come back. Sometimes blood results are back within a week. Sometimes they're not back 6 months. And so you will see judges taking away license if the results of the blood test are 0.08 or greater, or if there is medication, prescription or illegal, in the person's blood and there was bad driving, such as a crash or swerving, things like that. So with the DUI, the driver's license suspensions, there's a before suspension, there can be a during suspension, and there's definitely an after the case suspension. That's why it's so important to get a DUI attorney involved in a DUI case as soon as possible, because a DUI attorney can guide a person on what's going to happen to their driver's license. And in many cases in Indiana, we can get a person driving with some sort of limited privileges for work, school, things you have to do. That is not automatic. You have to ask the judge. The judge has to hear evidence, and then the judge has to actually slam the gavel and say, okay, I'll let you drive for 1, 2, and 3 reasons. And then you have to provide an order. You have to keep that order with you. That's called specialized driving privileges. Not all judges do it, but the ones that do it, we like them a lot because it allows people to keep working, keep supporting their family, and then the DUI has a minimal impact on their life. And yeah, some people say, well, Mark, they did it to themselves. Yeah, but their kids don't deserve to suffer. Neither does their spouse or loved ones, because they can't work, can't drive. So license issues with DUIs are super complicated and not fun. But lucky for you, I know a lot about DUI defense, including all the fun ways a DUI can mess up a person's driver's license. If you have any questions about DUIs or DUI defense or driver's license and DUIs, give me a call, 317-632-3642. I will talk about DUI defense all day. But most importantly, remember, always plead the fifth.